Look, this is a withdrawal application.
801, we'll take it up tomorrow.
Very well.
Tomorrow.
Please, your lordship.
IA taken up for consideration. List the appeal for hearing on. You'll join the queue and then you'll have to wait for your turn.
Please.
2611.
Grateful, Miller. Grateful. Please, Miller.
803, now that we have tagged it with Sahil,
Please,
and Sahil in turn is tagged with Union of India versus Ashok Kumar.
there is no difficulty regarding.
That is not before us.
No, Miller, I'm saying something else.
Unless
The other
this
day-
matter remains on our board, you can't now make a mention for moving a miscellaneous application.
No, Miller, because that day what had happened.
Did you verify whether it's still with us?
Miller, this matter is with your.
Once we tagged it, it will go.
Miller,
We've already tagged it with Sahil. Sahil is tagged
Miller,
with
Sahil is with your
Ashok
lordship.
Kumar.
Miller,
Sahil is no longer with us. Sahil is now tagged to Ashok Kumar.
let it be tagged.
Ashok Kumar has not surfaced since a long time.
Miller, I'm not on merits. Miller, I'm saying
No,
something.
but unless the matter is before us, we can't entertain a miscellaneous
Your
application.
lordships have.
Did you verify with the registry
I
whether it's
did,
with us?
I did because
They don't apply their mind either. Please do it again.
Miller,
Otherwise, you'll have to make a mention before the chief's court because this matter may not be on our board.
it was only regarding the stay application.
Even that, once we've tagged it with another matter, it no longer remains with us.
Miller, as I was informed by the registry. Miller,
Did they
it was-
know that it's already been tagged?
Miller, they said that the main matter Union of.
I will check up with the registrar. As matters stand, my impression is that this will go with
Then
Ashok
Miller,
Kumar.
let me just verify this and get back, Miller. So after
Very
lunch, Miller. So I'll come.
Do
back.
that.
Grateful.
With your lordship's permission, may I mention a matter which is listed tomorrow, your lordship? It is item 50. It is item 23 tomorrow.
What
Your
do
lordships on the last occasion, Mr. Gopal Shankar Nayan had mentioned it, and you had said that if it moves down the list, we can mention and request.
What happened? It's moved down.
Your lordship, it's.
No, but have they added hearing matters or
Your
have they
lordship,
added fresh
Your
matters?
lordship, after notice matters only. Last time, also after notice was starting from 4, and we were item 15, and this time we have moved down to 23, your lordships.
I'll check the list. Please ask them to. Whoever is in charge, ask him to come and meet me during lunch.
So, Ash, there are two IAs. One is for clarification of one of your orders. That is the reason for the urgency. So
You can make a mention. Tomorrow we'll take it up out.
it's on board.
It's on board.
Okay,
You can
before
ask for it to be taken up out of turn
Yes, your lordship.
for consideration of your IA.
Grateful, your lordship.
Item number 1.
I'm seeking 2 weeks' time, my lord, to file certain important document. There,
No.
will-
You've not filed a counter also.
no, my lord. I have
You
received.
don't want to file a counter.
We filed within 2 weeks, my lord.
Very
We
good.
file it. Some
Joint counsel appearing for the respondent seeks some time to file a counter after this, along with relevant documents. List on 3rd December.
obliged.
Item number 2.
My lords, this is a matter wherein the director of PACL company, my lords,
This
There are
covering,
41
you've now added 6 states amongst the respondents.
my lords,
How many FIRs are you?
41
Where is
FIRs.
the question of clubbing of FIRs, if it is, say, an interview on TV or something like that, and several people find a grievance with it, then you can ask for clubbing of those FIRs because it's one single incident. If you have taken several complainants for a ride, each of them has a separate cause of action against you.
My lords,
You can't say that I have taken 1,000 people for a ride. Therefore, for my convenience, let all 1,000 of them come to wherever I want the trial to be.
my lords,
That can't be.
my lords. Two things, my lords. Firstly, my lords, this
For
honorable
one
court-
thing, those complainants are not before us.
my
We are
lords,
not going to direct clubbing of these
My lords.
FIRs
my
without even knowing what inconvenience
My lords,
those
may I
complainants would
may I
have.
kindly submit, this honorable court was seized of the same matter, which is where, my lords, Ravinder Singh Sidhu, this is the judgment.
There's one writ petition which seems to have been dismissed. What was that?
That was, my lords, wherein all the transfers were sought and with the CBI. This is a case, my lords, which has been squarely considered by this honorable court by Justice Gawai as well as Vishwanathan. And the judgment came in as late as 19th of May. So second copy I have given.
Don't have a second copy. My brother did his own homework and got a copy for himself.
My lords, I'll give it.
You don't
This is the
need
second copy. I will see it on the laptop. My
My
lord,
brother has already done his homework and got a copy for himself because he obviously
Much
perceived that you would not be supplying two copies.
no, my lords, I have the copies. There are so many of books. So para, my lords, 10. 19 onwards, my lords. I'm obliged, my lords. That's exactly what covers, my lords, in this case. There are FIRs to the tune of 16, 10 various jurisdictions. And 19 onwards, the writ petition stands allowed in the above terms. We further direct while the first FIR will be treated as the first information report hereinafter for convenience principal FIR, the subsequent FIRs in each state shall be treated as statements under section 161 of the CP.
One moment, please.
Without going into the merits of the case, my lord, this particular petitioner, he was the director of the company, though he is a farmer with no bank accounts, with no office, with nothing. He was actually in village. CBI did not.
What happens in these cases, Mr.
Yes, my lord. Yes, my lord.
Eventually.
I totally honor that, my lords. As a matter of
We are not going to grant you a stable issue notice, that's why.
my lords, may I in the meantime also request this matter may kindly be taken up earlier with regards to, my lords, the interim prayer. Why am I pressing for that, my lords? Is my lords,
System is
kindly-
not here to serve the accused. You seem to have it
My-
the other way around.
my lords,
That
CBI
the system needs to serve the accused by clubbing FIRs, driving the complainants to a different place so
My
that they
lords-
give evidence.
my lords, may I suggest one
We
thing?
will issue notice because of that judgment.
Fair
on
enough,
that.
my lords, what I'm suggesting is, insofar as the other FIRs or other accused are concerned, this honorable court has been pleased to give them interim bail for the purposes of seeking the bail across other high courts. So that is the interim
Nothing at
prayer that
this
has
stage.
been made.
Nothing at this stage. Issue
So-
notice, returnable on 19 January. So
My
it
lord,
shall be effective
may I
by
kindly
almost
request the
2
matter
weeks.
to be heard little earlier, my lords?
You just filed it, you can't have everything.
No, my lords.
Sorry.
My lords,
Consider it an achievement today that you managed to get a notice order. I was inclined to dismiss it straight away.
my lords, I bow down to
But-
that grant of relief.
So be happy with that for today.
My lords, one thing that I would particularly want to highlight in this particular case is CBI did not seek his arrest. CBI did not file charge sheet
We will
against
see
him.
when the CBI or whoever comes after notice is served, then we'll consider. Next
My
matter.
lords, may I kindly request for an early date?
Next matter.
Today, my lords, his son is
Next
getting married.
matter counts.
All right, all right. Obliged, my lord.
My lord, I'm in custody since 6th of April
It's a
25.
dowry death case.
My lord, it is. My lords,
And you admit to the fact that you beat her up a year ago.
no, my
And you
lord,
say that she committed suicide a year later, therefore
just
it's not.
two submissions, my lord,
Then-
and then as my lord would say, my lords may kindly have, my lord, they say it's a dowry death. My lords may kindly have.
It is a dowry death. Look at the dates. When did she get married? When did she die?
No, my lords, it could be anything, but not a case of dowry. my
Where?
lords.
The
Money
father
was
has
not an
images.
issue.
Father has messages from her, images of how.
No, that
She
was in
sustained
November
injuries.
23, a year ago, my lords.
So it doesn't, it means that she has.
No,
to
it was.
Forget everything that happened.
Duality, my lords, but not dowry death. My lords, for a moment.
And
have
she
page number
suffered an
27.
abortion also. We don't know why she
No,
suffered.
yes,
an
my lord,
abortion.
that is also the only two. First is on actual medical condition which she was undergoing, and second is that there was free flow of money between.
Not resist.
They kindly have page number 27, my lords, for a moment. My lord, this is the summary of the funds that got transferred between the deceased and her paternal relatives from April of 24 till 25th of
Not at
December
this stage,
24. And my lords, I was
You've been
continuously.
there for 5 months, sir.
No, my lords, not at all.
7 months.
My lords,
We are not
only 2
inclined.
minutes, my lords, just
Not at this stage.
my lords, I'll be out of the courtroom on my own. My lords, just give me 2 minutes to submit 2 points, my lords.
Yes.
Firstly, my lords, at page number 30, I am continuously transferring funds to her
We've
account
seen
for her
that.
personal use. And she in turn is transferring funds to her in-law, to her parents and relatives who happen to be the witness in this case. So there is absolutely no call of money from.
What are the messages and images
My
available
lords,
with the
I
father?
will
of
come
the
to that
deceased?
also, my lords. Now, second is her medical condition. My lords, may kindly have it just come in post-mortem report. My lords,
Page?
it is at page number 38.
Yes.
My lords, at page number 38.11, it says internal and external genitals, uterus is empty and small. Now, my lords, small is what I will emphasize upon. Now, my lords, may kindly have page number 44. Now, she was getting her treatment in Ahmedabad. She was living with me in Ahmedabad. We moved out of Gwalior in November itself, November 23. Here, my lords, would see she had a missed abortion. She had 3 abortions, my lords. This one is a missed abortion, and it happens when it's a silent abortion, when fetus stops growing. She happens to have a small uterus, and that was at the root, my lords.
These are all suppositions.
No, my lords.
Once there is
no,
an admission by you that you did beat her up
No, my lord,
in
no
September
submission.
to November.
No, my lords,
2020.
no submission, my lords. I mean, no
Say
admission
that-
is there, my lords.
Say that it was a year ago.
Yes, they produced certain documents. I said those documents pertain to 23.
So at least 23 you're admitting that you used to.
No,
beat
no,
her
I
up.
did not do that, my lord. That injury could be.
Delay
because of
condone,
20%,
however,
my
we
lords.
find no good ground and reason to interfere with the impugned judgment passed by the High Court at this stage, especially if petition is dismissed.
Item number 4.
No counter, you want time. Very. And counsel appearing for the state of Bihar seeks some time to file a counter. Usual order. Earlier interim order dated 22. Interim order dated 22/9/2020. I shall stand extended till the next hearing. List on 21st January.
Item number 5. Please.
No counter in this also.
Lords, I prayed for 1 week time to file counter.
Same order. Same date. Interim order is 19/9.
Much obliged.
Item number 6.
Look, this is a purely a civil nature dispute, which is given the criminal color. And
That might also help you with regard to section 50 CRP. Issue notice returnable on 10th, 17th December.
service to standing council.
Service. Learn council responsibility.
Item number 7.
Yes, Lordship.
Against a withdrawal order.
Yes, Lordship,
SLP against a withdrawal order lies.
it has to be Lord because
Right?
we filed.
After arguing at length,
Yes,
learned council seeks to withdraw.
for
That
the
really
reason,
indicates that the court was not inclined, so you
Court
withdraw
was-
it, and then you file a SLP.
we filed.
We
a
are not going to
recalling-
entertain
we filed a
SLPs
recalling
against withdrawal order.
We filed a recalling order. It then said, the court said that a criminal court does not have any power to reissue or
No power of review.
re-observe his own.
To it.
Please, my Lordship, otherwise I would have gone
We,
for.
we find no grounds made out to entertain the
Lordship,
special leave petition
Lordship.
filed against a withdrawal order.
Give me one moment, my Lordship.
Sorry, council.
It's a.
We are not going to
Lordship,
open these
just
doors.
see the merits of.
You
the-
can't withdraw your
Lord,
case
it's a-
before the
it's a-
High Court and then try to make out a grievance. before
Lordship,
us.
it doesn't lie. I cannot lie.
Anyhow, even on merits, you have no case.
I have
The
case,
status
Lordship.
report,
It's a.
status report shows that you chased the other man in your vehicle.
Lordship.
You
he-
had a
He
pistol,
shot me first.
so
he
you
shot me
chased him
first,
and then
Your
beat him
Lordship.
up.
The
This
SSP,
road rage in
SSP filed.
Punjab and Haryana, well documented, so we don't.
It's
need
not
to say
that,
anything.
Lord, it's a different case, my Lordship. My
Sorry,
Lordship may not.
In any event, we will not entertain SLPs against withdrawal orders. So dismissed.
Item number 8. After the event, item number 8.
No letter. No letter, madam. Anticipatory bail in a matter of this nature. Are you going to argue? Or you want a long date?
1 week time.
Adjournment is sought by the land council for the petitioner based on 7th January.
Item number 9.
Please, my lords. My lords, this is a case of lynching where one person was killed and multiple people were injured, my lord.
Why was he not named in the FIR?
My
According
lords,
to you, there's a video,
yes, please, my
then
lords.
why was he not named? Did you not know his name?
My lords, I was an injured party. I did-
Exactly, so how could you have not known him then?
My lords, I have mentioned the viral videos taken in my farm.
This was in his cow shed.
Scout
So
shed.
you did not know whose cow shed it was.
My
This
lords,
not naming him in the FIR is what causes the doubt here.
my lords, sorry, it's named against unknown person. My lord, the police is the.
But now you give all these details, you say that he was there, there's a video also,
Please, my
that
lord.
his son surrendered,
Yes, please, my lord, the case diary.
but you
mentions
don't
all
name him
this.
at all.
My lord, the case diary mentions there's been people, independent witnesses, the viral video, they've identified him.
What about this video that you have? Did you not place it before the
Yes, please, my
introduction?
lord, it's a part of the case diary, page 61 of the SLP, my lords, which is the case diary.
Then why did the High Court not consider that?
My lord, if you see the impugned order of the High Court, its bail is granted on the first day. Only the state is issued notice, the state argues the same, my lord. And it's my lord, we see the nature of the order as well. My lord, 62.
We are informed that there was a video which was available with the investigating officer, which showed that 8 to 10 men were beating the victim, and respondent number 2 was one amongst them.
Please, my lord,
This aspect-
62 identifies him.
This aspect of the matter was not considered by the High Court. Issue notice part
52, my lord.
52.
52, page 62,
Right.
part 52. Is Bagesh, right?
That's one of, what did I say?
Here is a video which was available with the investigating officer which showed the 8 to 10 men were beating the victim, and respondent number 2 was one
Was identified as one.
amongst them. This aspect of the matter was not considered by the High Court.
High Court. Issue notice, returnable on 4th December.
My lord,
Will it be enough time though? 11 December.
my lord,
11 December.
permission may be allowed because
I
we
don't
were
know
not
whether it is
party to
11th
the
also. will
to the High Court petition.
We can't take it up so fast. The notice may not even be served on 15th January. 15th January.
Grateful.
This is a 420 page.
Yes, sir. Sir, in the present bail application, sir, in this matter, sir, this matter is purely civil in nature, where it is given.
22 crore.
Sir, 20, sir, it's 22 crore matter, sir, whereas, sir, there is no trail of money, whatever, it has been charge sheeted, it has clearly specified that it is 16 crore in cash, sir. So there is no trail of that money, sir.
So far as Shah Rukh Khan is concerned, he lent you 39 lakhs.
Sir, coming to that, sir, 39 lakhs, sir, we have returned him around 6 to 7 lakh rupees, sir. So it is
Some business
it's a
transaction.
business transaction only. So it's a scrap business and it was clearly mentioned.
Issue notice, returnable on 12th January.
Item number 11.
What are 103, murder case.
Yes, my lord. My lord, general and omnibus allegation are there, my lord.
Asma Kushwa, the eyewitness identifies you as one of the SMEs.
My lord, the complainant is here, sir.
The eyewitness is there. She's the one who informed the complainant.
Yes, that's right, man. That's right.
And she identified you as one of the people who chased him and beat
Yes,
him up.
in one breath, she names everyone in the person that she knows.
No, If you are a part of a mob which kills and then
I was not the part
somebody
of
sees,
this.
you are part of that.
This is my case, my lord. I was not the part. I came subsequent. It is allegation that
No, but you also came and beat him up.
Yes, my lord.
Asma says that you also were part of that.
My lord, it was me. I was.
Chase the deceased also.
No,
Chased him also.
This is allegation.
First one said, then Lalji Gupta, that's you, Rajmani, and Babu Kushwa
They were
also came and beat him.
There were previous
With
issues
sticks,
between these
batons,
parties,
and
my lord. That's
axes.
why.
Not
Mr. was not present at this.
issue notice, not two of you, please. We find no good ground and reason to interfere with the impugned judge. Delay condone, however, we find no good ground. SLP is accordingly dismissed.
Item number 12.
Please, my lord.
12,
My lord, this is civil.
we have a letter,
Yes, my lord. We filed a letter.
and you want to file a counter in your own case. You are the counsel, is it? Sandeep
My
Devashish.
Mr. Das is leads me. He's the advocate on record.
Sandeep Devashish is the counsel for
For the appellant.
the appellant.
Yes.
And the letter is filed describing him as the respondent, and 4 weeks is sought.
I'm so sorry.
So we are wondering whether you want to counter your own case.
My lord,
If you have no faith in your case, then we'll dismiss it right away. We don't need to file a counter also.
I do apologize. I apologize most sincerely.
What do you need an adjournment for?
My lord,
Counter is now filed by the looks of it. Something we received yesterday.
my lord, Mr. Das is the advocate on record. I'm his junior. He's quite ill. So
Yes.
and an
Adjournment
allied.
is sought on the ground of ill health of the learned counsel for the petitioner. List on 4 weeks you want.
I'm so grateful.
List on 12th January.
12 January.
Yes.
I'm so grateful, my lord.
13. Mr. Shawan Aditya.
Yes.
Now, because you have a grouse with a judgment that I was a party to, it would be appropriate that this matter goes before a different court, so you do not feel that you were not heard by an independent bench. So we will send it to another court, so you can argue it elsewhere.
Whatever you, sir, my lordship.
You would feel that, is it not? If suppose I say something against you,
No, sir.
you would feel that you had a grievance with the judgment to which I was a party, and therefore I would obviously speak in favor of my judgment.
No, my lordship,
No.
I don't feel that.
It
because,
would be appropriate that this matter is heard by a bench in which one of us, my name, is not a member. Registry is directed to list him expeditiously before an appropriate bench after obtaining necessary orders from the Honorable the Chief Justice.
Item number 14.
It'll go before a different court.
14 lordships have issued notice on 31st October on
Yes.
identical matters, same party.
Yes.
5th January is coming up.
Delay no, 10 more. Tag with SLP
31642.
3164. 3164.
Wait for
Issue notice and tag.
15.
15.
May it please lordships.
Yes.
My lords, in this matter, the Honorable High Court, right, in the impugned order that is contained at page 1, no substantial question of law was discussed, my lords, only on the basis of factual aspect which was not even contained in the findings of the trial court
Concurrent
and
findings, though.
Pardon,
Concurrent findings, you do not have any documentary evidence of that partition.
we have filed,
How
my
do we
lords.
decide on
Partition, my
suspects?
partition was way back in 1942.
You
It is
have that
admitted by the
19
defendant themselves that
You
it
only
was an
have that
oral
order.
partition.
You have only that 1968 order, which has not even been filed, perhaps.
My lord, it was.
1968 order, which you don't even file, so we don't know what it said. And other than that,
We'll file it, my lord, today itself. It forms a part of the record, my lords.
that
It
doesn't
forms a
mean
part
that
of the record of the trial court. Trial court has
you do not
discussed
file
that.
it and thereafter file it after you take a cue from us. Sorry, counsel. These are concurrent findings and purely factual aspects. Delay
My
condoned,
lords,
however, we
at
find
least
no good ground
High
for
Court should have
petition
discussed, my
with
lord,
impugned
on
judge
substantial
asked
questions
by
of
the
law.
High Court, especially petitions according to districts.
Oblige.
16.
Similar matter dismissed. Who's here?
Please, your lordships, I am for the petitioner. In all
We've already
fairness,
discussed.
connected.
Yes.
Yes, your lord.
We find no delay condone, however, we find no good ground in reason to credit it. Especially petitions according to districts.
Item number 17.
May I please, Lord?
Yes.
Lordship, some similar matters are already before my.
No,
Lordship,
430 days delay,
No, Lordship,
62.
I have two arguments to make.
Whatever argument you have, we do not have any discretion under the
I
provision.
totally bow down, Lordship.
Then where is the question
No,
of
Lordship,
condoning 430 days
Lordship,
delay?
two submissions. Firstly, here is a case where already a statutory appeal which was filed in delay.
Whatever it
has
is,
been
you
admitted.
can't file an independent appeal with 430 days.
Now, Lordship, allow me just 1 minute. As to what remedy would I have? What I had done
That's
earlier
for
was-
you to examine, not for us to advise.
In fact, I had filed an SLP first because I was
SLP
very well
would
aware.
not lie.
Now, SLP was not permitted by the registry.
not
That's why I
lie.
converted to statutory with the permission to file statutory.
Yes.
Now,
Civil
Lordship-
appeal also would not lie after
Now,
430.
Lordship, one more submission. Here is the case that the problem of the present petitioners and many others have arisen only in the year 2025. Now, this particular judgment passed by the NCLT is in 2023 and affirmed by the appellate tribunal in 2024.
Sorry.
Now, what remedy would I have?
This appeal is filed under section 62 of the Insolvency and Bankruptcy Code, 2016, with a delay of 430 days. This is well beyond the permissible condonable limit under the Act, and we have no choice but to dismiss the appeal on that short ground.
Lordship, may I make
The
one?
condon delay petition as well as the appeal accordingly dismissed.
Lordship, may I make one submission, Lordship? In fact, one statutory appeal with delay has been condoned by this honorable court and has been tagged with the main matter. It is reflected in the office report itself. It is reflected in the office.
Is that so?
Yes, Lordship.
How will it be?
Lordship,
condoned?
Lordship, it is there.
Lordship, that's a separate.
We
whole
cannot
matter.
condone.
Lordship is nothing to do with this matter.
We cannot condone delay
Lordship,
beyond 60.
So serial number 4 in the office
45
report.
plus 50.
Lordship, I totally bow down, Lordship. Serial number 4 in the office order.
It's pending,
Office
it's
report.
not condoned.
Yes.
No, Lordship, the order says delay condone. I have the order, Lordships. Delay condone, the order is of 12th November 24. That is why I refer to that.
We
I
have
have that
no
order.
such discretion. If that bench overlooked the statutory provision,
Lordship,
merely because
Lordship,
one wrong was
Lordship,
made doesn't
my
mean
lords
we
were
follow.
party to that bench, Lordship. I have that order, Lordship.
Where is that on?
Lordship, it's in my iPad. Can I hand it over, Lordship?
Hand it in.
Please.
Your Lordship, Mr. Datta has joined online.
What was the delay there?
Lordship, impugn was of February 24 and the finally came up in November 25.
It might have come up, but if the delay was less than 15 days, then we would have condoned. The delay was.
Lordship, if my lords want,
We
we pass
would
it over,
not
I can
have-
find out more
We
details
would
of
not
it.
have condoned delay beyond that 15 days
But
condonable limit.
Lordship, the order reflects so. Lordship, that's why.
It only says delay condoned. It doesn't say how much.
Lordship, I'll
delay.
pass it over. I will get all those details.
In any event, I'm not going to follow suit. Even if I was a member there, unfortunately, I might not have noticed it. But
Lordship,
we can't act in violation of the statute.
totally
142 also doesn't
Lordship, I
permit
bow
us to
down.
do that.
Lordship, I bow down. That's why I had first initiated a 136
Sorry, Khan.
petition. Now, Lordship, just 1 minute, Lordship. In fact,
Whatever it is you wish to say, we have no option. We don't have discretion here.
petitioners are also rendered remediless. I will just want
Then
to explain it.
it is for you to decide what you wish to do.
Because
A civil appeal is barred. By limitation, we cannot condone the limit.
Lordship may grant me liberty to take my chances in 136 because that is what I attempted.
There's already a judgment. Justice Chandrachud's
I bow down,
judgment.
Lordship. I'm aware of that.
Then,
I'm
where
aware.
is the question?
No, Lordship.
That's right, my lord.
That's a three-judge bench, if I remember right.
Correct, Lordship.
Then
Correct.
where is the question? We can't agree with it.
Present.
That's right, my lord.
Remediless. That's the difficulty,
Then
Lordship.
it's for you to decide what you wish to do.
No, Lordship may grant
We
me.
can't find the remedy for you.
But Lordship, the main matters and the civil
Sorry,
matters
Lord.
are pending before this honorable
This
court, and that is why I
can't
am.
be entertained. Sorry.
Now, Lordship, can I pray that I be granted liberty to approach the NCLT, Lordship?
We will not say anything. It is for you to think of, imagine up whatever remedy you wish
No,
to
Lordship,
and
grant
then
me
pursue
liberty
it.
to withdraw to pursue before the.
We
before
won't
any
say
of-
anything. If you
Lordship,
wish to withdraw, just withdraw.
Lordship,
We won't say
Please
anything.
don't grant this liberty, my lord. If he wants to withdraw, let him withdraw.
You counsel.
as my
You
lord.
cannot open
Lordship, may
even a
grant me
window.
grant me liberty to.
Very well. Learned counsel. Having argued for some time on the condoned delay petition, learned counsel for the appellants. Petitioners at public appellants seeks permission to withdraw the condoned delay petition as well as the appeal. Permission granted, the condoned delay petition appeal are accordingly dismissed.
Great.
Please, Lord, it's a very interesting proposition in this case. The arbitrator.
Rohan Builders also does not say that
No,
this
Lord.
kind of exercise
Lord,
can be undertaken.
Let me just have 2 dates, Lord, and then probably I will be able to, Lord.
We already have all the dates necessary. Mr. Raval,
Lord, may I
which date do you want to give us?
Yes, Lord. The appointment of the arbitrator is not on 3rd of March 2022.
Yes.
As per 29A1, it has to be, Lord, within 12 months from the completion of the proceedings.
Meeting.
The completion of proceedings were on 15th July 2023. With the consent, with effect from 14th July 2023, parties extended a period for another
6 months.
6 months. Now, the arguments concluded before the arbitrator within the extended mandate, Lord, that is
14/11/23.
Lord, it was the duty of the arbitrator to inform us that it has taken 61 days.
You knew when the 6 months were getting over.
I'll explain. I was not a fence sitter as I have been branded to by the.
You knew exactly when the 6 months would get over.
Kindly see, my lord, there is Rohan Builder of this court.
Rohan Builders does not apply to this
situation
at all.
With respect, and then Lord,
it says that if the application is pending, an award is passed, then it's a different situation.
No,
Here, there's no application at all.
So.
He passes the award in your favor and then you file the application.
Lord, with all humility, does not say so. Lord, may I read it, the Rohan Builders, Lord, for a minute?
Read it.
Please. Para 11, my lord. Please pass it on the judgment. Please pass it on to the manual. Please pass. I'm sorry, I'm taking my lord's time.
Oh. If you're able to make out a case,
yes,
it is interesting.
Yes, yes, Lord. It's a case worth Lord consideration because this situation has not arisen.
After the award.
Lord, it is not my fault. Lord, had it been against me, my lord, also,
then
things would have been different, my lord. The other party would have also come. The same vice versa, my lord.
Doesn't mean either of you can do this.
Lord, see, para 11.
Yes.
My lord, para 11, my lord. The word terminate. Lord, may I read the provisions of the act before I read this paragraph? Lord, 29A4. Lord, may I have 29A4, my lord.
Yes, arbitration.
Page 28 of the Universal Severe Act.
Yes.
The parties may not be, if the award is not 29A4, my lord.
Yes.
If the award is not made within a period specified under subsection 1 or the extended period specified under subsection 3, the mandate of the arbitrator shall terminate unless the court has either prior to or after the expiry of the period so specified. No, it doesn't say that after the expiry of award.
Expiry, it doesn't say after pronouncement.
It doesn't say so. So this provision has been interpreted in Rohan Builder in paragraph 11.
Yes.
The word terminate, para 11. I'm trying to make out a case, Lord. Sometimes this is a new proposition. Even I was also confronted with. The word terminate in subsection 29A4 makes the arbitrator tribunal function officer, but not in absolute terms. The true purport of the word terminate must be understood in the light of the syntax of the provision. The absence of a full stop after the word terminate is noteworthy. The word terminate is followed by the connecting word unless, which qualifies the first part with the subsequent limb of section, that is, unless the court has either prior to or after the expiry of the period so specified, extended the period. The expression prior to or the after the expiry of the period so specified has to be understood with the reference to Lord. And now, Lordship may kindly see subsection 4 of section 34. That's very classic thing which the London High Court has Lord failed to address that issue, my lord. 34.4, my lord.
Yes.
This is now been added. Because this proposition is not 34.4. On receipt of an application under subsection 1, that is what the objections the other party would file, my lord, in the court, which is aggrieved of the award, the court may, where it is appropriate and it is so requested by a party, adjourn the proceedings for a period. Now, what is court, my lord? For a period of time determined by it under to give the arbitrary tribunal an opportunity. Arbitrary tribunal an opportunity meaning whereby, my lord, if the objections are filed, the court says function officio. But still, the word is arbitrary tribunal. To resume the arbitrary proceedings or to stay such other action as in the opinion of the arbitrary tribunal will eliminate the ground of setting aside on one of the grounds. So this is one of the grounds they have taken. Lord, yes. Otherwise, Lord, this 34.4 would not have been there. The legislature would not have incorporated the provision. Lord, it
Let's
requires
see what Mr. Gaurav has to say.
Yes, actually, Lordships, the data very clear. The award is passed. we file a section 34. We specifically take a ground. Noting this ground, the award is stayed in August. After 4 months, they realize that this is going to be difficult to sustain the award. So in January, Milos, they filed this application on 29/5. Now, after the award has been passed on that day, the arbitrator had no authority. What Rohan Builder said, if you make an application, then the proceedings can continue and award will come. If the application is not there, the arbitrator should have requested the parties to say, please take an extension if he's not in a position, or the parties should have written to the court or the arbitrator saying the period has come to an end. This application is filed 1 year after the period has got over. So therefore,
only difficulty is the High Court seems to say that the proceeding should be pending.
Yes, Milos.
That may not be correct.
Correct, but
speaking.
yes.
But
in the facts of this case, Lordship may leave that question open, but the Lordship doesn't require interference. A 34 is filed. My vested right to challenge the award will get taken away.
they will only clarify that as
Yes,
One
beyond
more
that, there's nothing in this.
One more aspect, Lord. Lord, what was my fault, Lord? The arbitrator did not render the award within
Your
60
fault
days.
is
Within
not
60 days.
filing the application.
Lord, therefore, Lord, there is another
If you
provision.
had sensed
There-
that the award was going to come in your favor, what prevented
Yes,
you from?
there is another provision in this statute, Lord, 1329(5), Lord. Lordship may kindly see. The second proviso, 29(4), Lord. It says, Lord, second proviso, Lord. Provide 29(4), second proviso. Provide first proviso. Second proviso. Yes, first proviso, Lord. Provided that while extending the period under this subsection, if the court finds that the proceedings have been delayed for the reason attributable to the arbitrator tribunal, then it may order reduction of fees of the arbiter. This is a penalty clause on the arbitrator. So, Lord, court could have extended it by imposing a penalty.
Why
of
did you
of the
move
fees.
the application within time?
Lord, one more aspect, Lord. There are two judgments of the
At
Delhi
least-
High Court, one in my favor, one other. Then the single judge should have referred to a larger bench, Lord, at least. It should have been, Lord, so that there is a Lord.
So the High Court was incorrect in stating that an application under Section 29, capital A of the Arbitration and Conciliation Act 1996 must invariably be moved during the pendency of the arbitral proceedings. In the light of the decision of this court in Rohan Builders within brackets India Private Limited versus Burger Paints, any issue?
No, Lordship, sir, I was just clarifying to my learned friend that it could be moved anytime prior to award, even if the period had
Even
got
after
over.
the period is
It has
over,
got
it can
over.
be moved,
That's
but
fine. Before the
before
award,
the award is-
yes, Lordships are clarifying this, as I was saying.
before,
With the light of the decision.
of this
Lord, it
court,
would amount to
Rohan
the
Builders
starting of the
within brackets
arbitration.
India Private Limited versus Burger Paints India Limited, 2024 SCC online, Supreme Court 2494, which clarified that of the term of the arbitrator in accordance with the provisions of the section itself, comma, we find no error in the judgment of the High Court holding that the award passed without any such application having been filed cannot be validated by granting extension under section 29 of the Arbitration and Conciliation Act at that point of time. Especially petition is accordingly dismissed.
Lord, can I suggest one proposal, the Lord, to cut short the litigation that since 34 would pending, it could take time. You can, Lord, with the consent appoint a new arbitrator, save the time, cost. It's a very fair proposition.
We go before the High Court. We are not going to.
Rigmarole of Lord, another exercise, paying fees. Anyway, thank you,
go
Lord.
before.
Obliged.
Number 19.
Live for the petitioner. So though the order is invited, Mullah, and the trial was expedited, but we are prosecuted for 490 days. Married sister-in-law and brother, that is absolutely.
Your counterpart, having argued for some time, he asked for quick
That's
disposal.
true, Lord. But despite of that, Mullah, the trial has
Consent-
not progressed. The High Court had said within 6
Take
months.
it up, you take it up with the High Court, then, that the trial is.
Your Lordship grant the liberty to move the High Court.
No, we won't grant any liberty.
The
You take it
6-month
up.
period, Mullah, is already over, and the petitioners are prosecuted of 498A. So one is Mullah, married sister-in-law and her husband, Mullah.
You either move the trial court and ask for expeditious disposal in the light of this.
Yes,
Otherwise, we are not going to say.
terrible. That's an invited
Delay
order. I
condone.
accept, Mullah.
However, we find no good ground and reason to interfere with the consent order passed by the High Court, especially petitions accordingly dismissed.
Item number
But there hasn't been delay, Mullah, in moving the.
Delay we find.
Obliged. Your Honor, I had put me a query on the last occasion that instead of filing a revival application, why did I file this appeal? Your Honor, after taking the suggestion and opinion from my seniors, I got to know that it was my inadvertent and bona fide error that I filed
What do
this.
you want?
I want liberty, Your Honor, to withdraw this appeal and file for revival of my original appeal.
The learned counsel for the appellant seeks permission to withdraw this appeal, reserving liberty to the appellant to take recourse to the liberty granted by this court with its order dated 1/4/2025 in the diary number. I think it's there in the
6946 of 25.
Item number 21.
Obliged, Your Honor.
21.
May I please, Your Honor? Lord, the Honorable High Court entertains a 227 petition to allow the
Government land.
No, my lord, it
Sorry, temple land.
temple land, my lord,
Temple
but my lord, my rights have been adjudicated under the Tamil Nadu Minor Inam Land Act, my lord.
You
I
had only Melavaram rights.
No, I had Inkevaram rights, my lord, that is
You
the
didn't have Iruvaram rights.
Yes, my lord, that rights are there, even now, my lord, High Court has
Dealt with this Melavaram, no. I had occasion to at least deal with it under the Estates Abolition Act
Yes, my
and
lord.
the Inams Abolition Act
Yes, under
in the
the
combined state of
combined
Africa.
Tamil
So
Nadu.
I
Estate.
know a little bit about this.
My lord, I don't know anything
But-
about it, my lord, but lordship may kindly
If
speak.
you have Melavaram rights, that means that the landowner is reserving the right to take part of the produce as rent. So you are given Melavaram rights, that means you need to give that share of the produce to the landowner.
No, my lord.
You do not become the owner.
No, no, I'm.
Kudivaram rights are your right to take your share of the produce. So unless Melavaram and Kudivaram rights are given, that becomes the Iruvaram rights. If both those rights vest in you, then you become the owner. So where is the proof that you were given Iruvaram rights? The High Court's finding is that you were a Melavaram right.
No, no, my lord. Lordship may kindly see that page 54, my lord, the original order 28/6/1969. My lord, it's a detailed order at page 54. Lord, 3 issues were framed. But I'm only concerned with grant of patta at page 54. No evidence.
Some special seva that you had to do.
Yes.
That or some Tamil
Temple
word is
seva.
there.
Annabhishekam.
So that seva you were supposed to do, for that the land was given. They did not become the owners thereby, whereby they could have sold the land like this.
No, no, my lord.
Come to page 21. They had transaction with the Melavaram holder. This is the finding.
No, my lord, here they say in this case.
And then there's a reference to a Supreme Court judgment which said that once a grant is burdened with service, then the right of resumption under section 21(7) of the Act is always there.
My lord, here.
There's this temple land trying.
No, my lord.
You're just trying to knock away temple land.
No question of knocking away, my lord. Lordship, I have been in possession for more than 80 years. That is recorded.
The High Court has said
In fact, High Court has said
you will be evicted in accordance with law.
But
And this liberty that is given to you, that I could not understand. What is this liberty in para 17.2?
Yes, my lord, it is.
Is this in relation to some other land?
No, my lord, same land, my lord.
Then once the grant is set aside, where will you have the liberty?
My lord, my lord, that is why there is my lord, this goes way back to 1901 transaction. My lord, all those things have been discussed and deliberated in the revenue order. My lord,
You will be evicted in accordance with law.
No, that protects is there, my lord, but lordship may kindly see, my lord,
and for some reason you are given liberty to file for partition. I don't know for partition.
No, my lord, what has happened was after the 69 and 72 order was passed by the authorities, the state would have gone up on appeal. They didn't file any appeal, they kept quiet, they granted me patta. Subsequently, there is change in the.
The fact remains it's still temple land. You didn't have any rights at all. You never had Iruvaram rights. Where is the question of your claiming absolute ownership over the land? Really, because you were given a right patta doesn't cure the defect in your claim itself.
But
even if that order, there's that other principle. We will not set aside an illegal order if it
No, I
restricts another illegal
I
order.
agree, man. If it.
So if we interfere now,
Yes.
it would mean that we are restoring that illegality, because on the face of it, you're knocking away temple property.
No, but I'm.
Without having Iruvaram rights.
I'm saying I'm only claiming Iruvaram right, which I'm exercising.
You
That's
have
all.
no Iruvaram rights. You have no document to show that you have Iruvaram.
Well, all, Lordship, that's what I'm trying to show. On page
The
56.
High Court's clear finding is that you had only Meluvaram rights.
No, but on page 56, they have considered all these
Sorry,
documents,
Kak.
my lord, then they.
Only relief, delay condone. Delay condone, however, we find no good ground in recent with the interim judgment passed by the High Court, which actually petitions according to last week.
Number 22.
22.
My lord, in other temple matters, Madurai, my lord, of course, that's a different issue. Your lordship are considering that in another bench, but not this particular issue.
This is also Madurai only.
This is also Madurai Meenakshi temple only. That also, my lord, there the matters are pending.
Well,
Lordship can consider to.
No. This obviously on the face of it, this is clear. That 72 order was illegal.
Lord,
Unfortunately, they did not challenge it till now. That doesn't mean that you can get away with the fact that the appellate remedy was not availed of. Therefore, you will take the benefit of that 1970.
We had all, anyway, we have a right under this judgment itself to claim our rights, my lord, which is there.
That liberty, for what reason it was given, we don't know, but you take advantage of it. Why does the authority say that this section 50 was not be available?
The coordinate bench should have followed the other previous decision in judgment. Page number 139.
We didn't understand why the High Court says that there's no power of
Yes,
when 51 itself is cited
Itself
power of
is there, and already there is a decision in judgment to that effect, which is reported page number 139.
There's a lot of delay though. I said, you had a review petition, is it?
Yes.
Yes.
Delay condone, issue notice, return below. Any interim relief that you need?
Status
Issue notice, returnable on 16th February. Status for obtaining as on date shall be maintained in all respects with regard to the subject land.
Number 23.
Wait, please, Lord.
The settlement now that you go before the High Court or the trial court, we are not going to settle the matter.
No, so what
We will close this matter in the light of your settlement. You go and get a compromise decree passed in.
Please, my lords, that's all we are asking for.
Not us. You go to the trial court.
My lord may say that we may go before the
Yes.
court and place it. The clients are present, their presence may be recorded. Both the
For what
sides are
reason?
present.
Both sides are
Because it's a
present.
settlement, so let it be recorded. The parties are present.
You've identified them.
Yes.
He's responding.
We are informed, as long as you identify them.
Yes, my client is here.
We are informed that the parties have settled the matter and entered into a settlement agreement
On 3rd of October
on 3rd October
2025.
2025. The parties are also present in person and are duly identified by the learned counsel. In the light of the settlement arrived at by and between the parties, we close this special leave petition, leaving it open to the parties to approach the trial court to secure a compromise decree in terms of their settlement in accordance with it. The special leave petition accordingly disposed of.
Please.
Number 24.
May it please my lords, lordship, I am representing a blind petitioner in
Yes.
the West Bengal
Yes.
selection matter. Now we had filed a contempt petition for non-compliance with para 47.
He has now been
given the appointment. There's just
given the appointment.
yes.
There's only one person in 24.
Yes.
What about 50?
50
council is here. 50 and 50.1.
Just before that, lordship, in 24, one additional aspect I just want to say.
Yes.
In para 47, it says that the period during which I was working through the SLST is not to be counted as a break in service,
Yes.
and my seniority is to be preserved.
Yes.
That's the only remaining aspect on which we
That
don't
will
have.
follow because once she joins, then the rest will follow.
So
We will just record that.
yes, that's my only limited.
We have no option, but we have to comply with the law.
This contempt case was instituted alleging willful disobedience to the directions of this court in para 47 of the judgment and order dated 3/4/2025, passed in that by Sati.
There is an item 50.
We are now informed by the Learned Counsel for the petitioner that in terms of the aforestated direction, the petitioner has now been allowed to rejoin
Yes.
duty in the post that he was holding prior to his selection
Yes.
in the year 2016. Then council appearing for, you're the state, the state or the service?
I'm for the commissioner.
Yeah, then council appearing for the state of West Bengal.
Yes, he is for the post.
States would state before this court that in terms of the direction of this court, the petitioner, once he joins duty, will be also allowed the benefit of continuity of service without any break. That's all. That's all we require.
Yes.
Continuity of service. Right.
So yeah, the
Contempt
pay
case.
fixation is also to be done accordingly as per the continuity.
Continuity of service with all consequential benefits,
Yes.
including seniority and pay fixation.
Yes, I'm so grateful.
We'll act as per a lordship judgment, whatever.
Yeah, this is exactly in the.
But once we said that, you will have to give him all that.
Yes.
Am I not taking up?
He participated in that fateful selection doesn't mean that he should be punished now if he's
No
an
question.
unfit
In any case, that is issues over a lordships have
Yes.
directed us.
In fact, I must place on record, I had pointed out that he's blind and he would like he has to be given a posting close to his hometown. So they have complied with that also.
That also. Very good.
Yes.
Yes.
In fact, earlier she was a little far away. We brought her.
It's a,
Yes,
it's a man or a woman?
Man.
It's a man. Somnath Naik.
Yes.
The contempt case is accordingly closed.
Yes.
There is an item 50 also.
50, the council is not here. You'll have to come back perhaps when the
All right.
matter is called. It was not tagged, so they would not
No,
be
no.
aware that this item is also.
I'll come back.
Yes. I'll also do that.
No, please. Lord, in this matter, this appellant, my lord, is a teacher by profession, and for 25 years he's been in the profession, my lord.
Perhaps notice has been issued in this.
Notice was issued.
Notice has not been.
Yet, my lord. Not yet. He was.
As the adjournment was.
The test was in, my lord, initially.
The only difficulty here, apart from the merits of the matter, is that the High Court says that the section 29 POCSO presumption would apply.
Please.
But 29 POCSO presumption applies to particular provisions.
Right.
Under which he is not being convicted.
Not the point is.
He's been convicted under section 8.
If your lordship will consider.
To which that 29 presumption doesn't apply at all.
I'll address that. However, lordships will just look into the foundational facts.
No, because
So
of
far as-
that now we'll at least have to issue notice. Because the High Court applies a presumption which cannot be applied to this.
Absolutely.
On that limited aspect in that case.
So on that limited ground, we'll have to at least look into it. And anyhow, the chamber judge seems to have granted him exemption. from
Yes.
surrender.
Yes.
I'm appealing for the state of West Bengal.
They are devastating, so to say. This is
Well,
a young girl going.
We've
to
seen that. He's supposed to be the
The
tutor.
rest of the students
Should I
are asked
show
to
a
leave.
one room house, my
And
lord?
consistently taken up by the
Eight
victim
students,
girl.
Lord.
Once-
These are the factors which now weigh at
This
least
well,
in
this is
giving
the
him
most
a toehold.
unfortunate part. my lord.
If not a foothold, at least he has a toehold right now.
I'm so grateful.
Let us see. You file your reply. There are
File our reply.
May I?
and council appearing for the state of West Bengal. Who else?
Plus,
I'm
I am
for
for
the state of West
I am for the respond number to the
Who is it?
defective
For the
For the
mother.
defective complaint.
For the mother.
For the mother.
State.
And council appearing for the state of West Bengal and the learned council appearing for the complainant. Respond number 2. Seek some time to file their counter affidavits. Usual order after that. And then
Plus, may I just-
exemption from surrendering granted on 15/10/2025 shall stand extended to the next
So grateful.
hearing. Based on 21st January.
Extremely obliged.
Will my lords only observe or not for final disposal on NMD?
Yes,
That can be
let-
disposed
let-
of.
let-
Once-
Let it come up.
Let
thereafter
me reply with title.
Well, I'll file it within a week. Well, that's fine.
That's a Wednesday. That's a Wednesday. So
I'm
let us
grateful.
see how things are on that day.
I'm grateful.
It might be, if the pleadings are complete and you're ready to argue, we'll take.
Very good.
I'm grateful.
ready.
Obliged.
Temporarily, they have given protection, man.
They've given
Their
protection.
protection, but they saying they are not admitting that there is a threat perception to mine. So, my lord,
We asked for a fresh affidavit.
Yes, my lords.
That affidavit you've not.
We have
filed?
filed, my lords.
Fresh affidavit, I didn't see that. Again, you say there's no threat.
Yeah, same thing.
We have made a complete assessment, my lords. However, pursuant to my lord's last,
Well,
order on the last
the
day.
first assessment, you go and ask the relation of the accused.
However, this
So
thing,
what kind of confidence are you inspiring now?
my lords.
Whom did you ask now? The accused himself?
The villagers, my lords. The common residents, the villagers.
Well, this kind of tainted exercise won't do. What is the point of going and asking the relation of the accused whether these people have a threat from the accused? Obviously, she'll say there's no threat.
My lords, however, on the flip side, my
So
lords,
you
we
just
have
pay
also,
lip services.
no, no, my lords,
Then-
we have also extended police protection to them, my lords,
We
pursuant to
will
my lords.
continue with the police protection. In the meanwhile, the readings are complete in the other matter,
Yes.
in the SLP.
No, they have not supplied the copy of the bail application, madam, because I'm the victim, I'm for the victim, madam.
You're a party there? You're not a party.
Not a party. But since both matters are clubbed to each other as a written protection, that's why.
Will implead you so more. Who is appearing in the second one, 26.1?
So I am appearing for the petitioner.
For the petitioner.
Yes.
Will implead the this Rajesh Singh. So you furnish a copy of your SLP to
My lord,
the SLP.
my lords, I
Only the
apologize to.
state of Haryana has been impleaded. We are of the opinion that as
That's it.
you are one of the victims,
I'm family.
the complainant.
Yes, yes.
You're the complainant.
Yes. That's it.
As the complainant, Rajesh Singh has independently filed a writ petition, which has also been clubbed with the special leave petition. We so moto implead him as respondent number 2 in the special leave petition, so that he may also be afforded an opportunity of hearing. Joint counsel for the petitioner in the special leave petition shall furnish a full set of papers in the special leave petition to the joint counsel for the newly impleaded respondent. Reply usual order after that. We are informed that you want to make it a separate order, make it a
Yes.
joint order.
Yes,
So-
Lordship, but I will put the SSP number.
In the writ petition, you say we are informed that the state has now provided protection to the family of the petitioner, though its perception continues to be that there is no such threat to either the petitioner or his family members. Let the protection continue till the next hearing, based on 21st January.
Lordship, my humble request is kindly pass interim order because the petitioner has.
They are saying on the one hand that they have threat from you and then you want to come out.
Against the petitioner, there is no any allegation, neither in FIR nor in a statement recorded.
We'll consider on the next stage.
Lordship, kindly give us,
Consider on the next stage, not.
kindly give us short date, your Lordship.
Item number 25, notice was not issued.
In which one?
Item
25.
25.
Issue notice.
My Lordship, kindly give us short date. Now 25 months expired when the prisoner has been in custody.
He's been there since when?
8 October 2023. To Lordship. There is a judgment passed by this honorable court. The bail application has to be decided within 6
8th
months.
October 20. Then don't give January, what date did I give? 21st. 15th then. One week.
Obliged, my lords.
Number 27.
It has been separated by the respondent.
Yes.
Time for countermand.
Adjournment is sought by the joint counsel
Adjourned
to the
is pending.
respondent to enable him to file a counter affidavit. Usual order, exemption from surrendering granted on 18/7/2025 shall stand extended to the next hearing, list on 18th March.
My Lord, resigned refund. I will file.
That also.
Grateful.
Obliged, my lord.
28 counter affidavit has come.
Yes.
May I request my lords to keep this on a non-miscellaneous day because we'll have to argue it.
Well, you need to file a rejoinder.
No need, sir. We'll just argue.
Counter affidavit. Joint counsel for the petitioner states that there would be no necessity to file a rejoinder to the counter affidavit of the respondent. He seeks time to advance arguments. List for hearing on 10th February.
Obliged, ma'am.
Earlier interim order shall continue to operate.
Let my appearance be noted. AOR's name has not been listed today by some mistake.
You want to enter appearance?
No, let my physical appearance be noted.
Obliged.
After notice, I want to file my reply on behalf of the state, your lordship.
Notice is.
Notice already been issued.
Notice has been.
On 22nd of September.
This page 195, please give us a better translation.
Which one?
195.
No,
PW4's evidence.
195.
The eyewitness's evidence.
Yes, ma'am.
What is the translation? You can't make head or tail of what he said.
Translation all throughout your lordship is like this. That
If
only.
the eyewitness, we need to see what he said.
It has already been recorded in the High Court and trial.
We had to just give him the widest possible meaning to every word.
Let them give the translation. Otherwise,
That's very
let them file a proper translation. Then.
They file a wrong
We had
translation
sit at such place,
Yes, ma'am.
at least the grammar part of it.
Yes.
We had sit at such place. From there, we saw that the accused persons were giving beatings to my sister,
Well, that-
brother-in-law and nephew. I escaped due to fear. On 20th, also reached my house while searching to nephew. We searched, but on 25th it was found dead bodies of my sister and Jijaji. Thereafter, we informed to police. I identified to accused persons at least.
This is the way that.
Renan Martin must be not twisting also, rolling in their graves.
The question is, Mala. This is a case where that the persons have been convicted on the basis.
At least we need to know what the eyewitness actually
No,
said.
Those things have already been recorded in the High Court itself.
The council appearing for the state of Jharkhand seeks some time to file.
4 weeks, your lordship.
And along with the translation copy, Mala, of the deposition.
Based on proper translation, all the witnesses.
Mala, this is the legal matter. I don't know
Oh, you don't know.
details.
Will you be- Then council for the state undertakes to provide proper translated copies of all the depositions
Will do that.
of the witnesses. List on 21st January.
In the meantime, they may be considered for bail. Mala.
No,
Well, they are already undergone 15 years.
three persons killed.
3%.
Baby also.
6% were roped in and 3% were acquitted.
Acquitted, no
And
doubt.
6%
We'll at least have to.
only on the basis of the confession that was not put to the accused on 330.
Unfortunately, I did not note as to why I issued notice, so I don't know. Why did we issue it?
I don't think he will insist now, your lordship.
After considering this fact,
I must have had a very good breakfast on that.
No.
What is that chance?
There are things in this case, Lordship will look into. In a PW3, PW4, whatever they have stated,
Killed and we issued notice.
Small child, your lordship.
in a small child that has not been proved through DNA.
What point did you make out of that day that you have also forgotten?
No, I got a point.
What is that?
The point is, first of all, the confessions based on the company these persons were obtained. The statement was not given by them.
You made?
But the point
My
is,
brother is also unable to recall why.
The point is, the persons were roped in based on the confession given by A1, in which they are alleged to have signed. So there is no such provision that the evidence said they have to sign in the confession made by A1. That is number one. Number two, the case is based on PW3 and PW4 evidence who are interested witnesses. So those statements, whatever they have given in that report, they were not there in the constitutional statement. That is admitted fact by the IO. Third point, the place where two bodies were recovered on 25th, the skull and hair alleged to have been recovered on 29th after their arrest on the same place. This is an open space.
From the same
place. That is the evidence of PW11. Kindly see, only one judgment.
Very well, anyhow, let the counter come.
Kindly see only one judgment on
Not a case for grant of bail without at least hearing. the
15
others.
years they are undergone,
Even then,
15 years they are undergone.
you would not be eligible under the state's policy for
not below 20 years, not below 20 years. That is the difficulty.
Child also 1.5
The
years.
child is not even proved. The skull and hair recovered at instant were not sent for DNA test. That is also not there.
Size of the skull would show whether it's a child.
That is not there, Moreover, PW11 says the very skull and hair
Not a
which were
case for
recovered.
grant without hearing the other side.
At least at this stage, at this stage, 15 years they are undergone.
Let the counter come.
More than the statutory period they are undergone.
You are not eligible. Life sentence is life sentence.
At least
Under the CRPC, premature release, 14 years complete.
433 years speaks of
Here,
that.
we don't know whether you are even eligible for premature release once there's a child murder.
It is not. But three
And
persons-
three persons. Normally, I think multiple homicides
the same
got
evidence.
convicted again.
On the same evidence.
Your conviction is
On the
confirmed.
same, how the court can take a different view.
Next.
This matter, if I may request the Lords to be for final hearing Lords on some day.
We'll have to hear the matter. The 23.
In fact, the Lords may consider of granting leave.
Lords,
Fix it for any day.
If we grant leave, there's a
Let's-
better chance of the matter reaching.
That Lords, we'll just file two documents.
Whatever you file, if
Yes,
we
it-
grant leave, at least you'll have 2 days a week.
It's a sort.
If we put it on a non-miscellaneous day, there's only 1 day a week.
That's
Your choice.
Then it will come after 3-4 years.
Why will it come after 3
There's a
years? We'll
state-
give you a date right
There's a
now.
status quo.
You'll at least join the queue.
There-
Thereafter, you'll
There is
slowly move up the ladder.
There is a status quo order, which is why I'm saying your Lordships may just
We'll give you a date, Council.
any date.
Leave granted. State list for hearing on. First week would be miscellaneous. So 6th.
First,
Will it be miscellaneous? No? So 13th. Oh, no, no. 13th is a Tuesday. So 21st.
Please.
You wish to file documents?
Yes.
Then council are permitted to file additional documents. In the meantime.
21st of
You wish to file also 21st of January.
Lord, sir.
31.
Hearing, my lords, the council wanted to place on government. Record the subsequent events, my lords. Subsequent event is that the High Court has increased the compensation to rupees 500, my lords. And the SLP filed by the government has been dismissed, my lord. So, Lord, may kindly say this.
When was that?
My lords, subsequently, my lords, I have filed the order, my lords, in IA number 227941, my lords.
Land acquisition, 1890.
I don't have.
28. You very.
My lords, judgment was passed, my lords, on 17/10/2023, my lords.
Then at least after that date, you could have filed an application under 28A.
My lords, Your Lordship, may kindly say, SLP has also been dismissed.
No.
Yes,
Why didn't you file an application under 28A
my
then?
lords, since the appeal was pending before since we had filed an appeal.
So you missed that bus also.
Yes, that's my lord.
No, but you could have done that without prejudice, isn't it?
That's. Lordship,
When was the SLP dismissed?
SLP dismissed on 27/1/2025, my lords.
Even from that date also time is over.
Yes, no. Lordship, that's council.
Someone is not vigilant about their rights, what can we do? You come here with this kind of delay.
My lords,
Clear.
just say,
1626 days.
my lords, the council was
No,
interested.
but at least that other door opened up,
Yes, ma'am.
and then you allow that also to close.
Yes, my lordship.
Then
Yes.
what is
Now
it?
the other
Same
line-
notification.
Same notification.
This
other-
judgment.
Yes, my lord. Same.
Then
Your Lordship, may kindly see the subsequent decision, my lords, on 17/20/2025 also, my lords. It was an appeal filed by the other
but
land.
council, we can't help someone who's not vigilant about his own rights.
Delay of 1,500 days was
We've already dismissed several matters on the ground of delay.
Your Lordship, may kindly see.
If you choose to be a fence sitter,
No, Your Lordship, kindly see, my lords. Your Lordship, may kindly see page 100. Page
you have no
100.
one to blame but yourself.
Your Lordship, may kindly see page 100, my lords. The explanation given by the deponent, my lords. Lands of the Dayaberi, my lords, and her husband Muniswamy were acquired, my lords. The papers were entrusted to the council for filing appeal, my lords. The appeal was filed in respect of the husband Munuswamy. It has been filed, my lords. Inadvertently, the council omitted to file appeal in respect of Dayaberi, my lords. So that is the same council had filed lot of appeals, my lords, and only in respect of this, the council has omitted to file, my lords. And we have clearly stated on affidavit, my lords, that Munuswamy has filed the appeal, my lords. Appeals are now some appeals are pending, some appeals have been disposed of by the High Court, granting enhancement of compensation, my lords. Your Lordship, may kindly see the order dated 17/10, my lords, passed by the High Court, my lords. The council for the government makes statement, my lords, that they will not object to the continuation of delay of 1,500 days
provided we don't seek any interest for the delay, my lords. Your lordship may kindly see this judgment 17/10/2025, lordship. I have handed over.
No, but how is it that you allow so many years to pass without even realizing that there's no appeal? If the husband's appeal was filed,
yes, my lords,
then at least you would have been in contact with your advocate. You should be aware that
page 100, yes.
There's no appeal in the name of the wife, and therefore you would have taken steps.
My lords, it was, you only see the page.
2015 is the date of the reference court's order. You don't do anything till 2023.
Page 2021, my lord. Your lordship may kindly see page 100, my lords. Your lordship may kindly see page 100, my lords. The affidavit filed, my lords. It has been numbered.
Have you sued the advocate?
My lords, the advocate is conducting the appeal of the.
Therefore, you can't sue.
Your lordship may kindly see genuine reason, my lords. Otherwise,
where is the genuine
your
reason?
lordship may kindly see page 100, my lords.
If you feel that once you give a case to the advocate, it's his headache, I don't need to bother at all.
Yes,
then you will have to pay the consequences.
I had been following it. The council has filed.
How would you have followed up if you did nothing for 8 years?
Not 8 years, my lords.
2015, 2023.
21 minutes. 21 minutes.
No, your this appeal is filed with delay in 23.
21 minutes. 21.
21 or 23?
24/9/2021.
21
minutes.
Your lordship order is 20. Very good.
Now, your lordship may kindly see page 99, my lords. Page 99 of the affidavit. Para 2, my lords. In the middle, I was also under the impression that the appeal has been lodged. I am a senior citizen and
where are you reading?
Para 2, my lords. Page 99, para 2, my lords.
Yes.
My lords, the property is located in the heart of the city and the same has been accepted by the respondent. The order was passed on 29/7/2015. The order copy was supplied originally and lost. I have also instructed my counsel to prepare appeal along with the rest of the land owners. I was also under the impression that the appeal has been lodged. I am a senior citizen and also hold French passport. Since I am a pensioner, at times I was called upon to go over to France to complete the formalities. I am also producing the details of travel in annexure.
So she is an educated lady.
Your lordship may kindly see, my lords, page 100, is very important. On my return to Madras, I had inquired my counsel as to the stage of the appeal.
So was she missing from 2015 till 21?
Your lordship may kindly see, my lords, page 100 top, my lords. So far, my lords, I have been diligently prosecuting the case would be obvious from the fact that the property standing in my name and located in so and so. So far as LOP is concerned, the same was filed with delay and was controlled by this honorable court in CMP number. Likewise, the appeal filed by myself as against LOP number, this honorable court had entertained it and the same is numbered as 93 of 2018. My lord.
So you are in the habit of regularly filing with delay.
My lords, the appeal, my lords, may kindly see page 98. Diabetes expired during pendency of LOP proceedings, my lords. The same Munusami who has been, your lordship may kindly see page 98. Munusami had handed over the papers, my lords. His appeal has been filed. Inadvertently, the council has omitted to file.
No, but going by your statement,
yes, your lordship.
Was she gone from 2015 till 21?
My lords,
did she go off to France for 6 years?
She died during pendency of LOP, my lords, in 2000.
Very well. Oh, he says that he went to France.
Yes, my lord.
So was he in France then for 6 years then?
My lord, he was having pension from France, my lord. He was an employee
Maybe
of.
So, but he said that on my return. So do we take it that he was gone for 6 years then?
No, we have also produced the travel details, my lord, and appeal has been filed. Your lordship may kindly
this kind of delay, it's the exchequer who has to pay for this.
My lords, we will.
And if people who are,
your lordship may kindly see this latest order, my lords, of 17th October.
We have dismissed several matters.
17th October, in respect of the same notification, the council has made a statement. Your lordship may kindly
have
see.
you?
No, I have. Your lordship may kindly see this.
That is before the High Court.
Your lordship may kindly see very same notification.
All the High Court.
Your lordship
for the High Court.
High Court.
What is the delay?
Delay of 1,577 days.
I don't even know. Not even aware of
yes, my lord. Your lordship may kindly see page. Para 3, my lords. Learned counsel for the respondent says that there has been delay on the part of the claimants in filing the present.
Then you ask, go back then. Go back and ask.
Let them go back.
My lords, appeal may be restored, my lords. Delay may be controlled. Appeal may
go
be.
back then.
My lordship may kindly see.
The High Court can't take inconsistent stands.
My lords, yes, your lords.
If they refuse to condone 1626 days, how did they condone 1577 days?
Your lordship may kindly see, my lords, has been condoned at the specific request of the learned counsel for the respondent. Your lordship may kindly see that such period of delay.
Sir, that's a good ground. You bring this order to the notice of the High Court.
Such period of delay shall be excluded while calculating interest, my lords. Your Lordship, may kindly see, learned counsel also says appellant would have to pay the necessary.
You can go
Your
back, counsel.
Your Lordship, we have also.
We have dismissed too many matters to now deviate from that course. So your better option is to withdraw this and go back to the High Court. In your case, we will make that mention.
Your Lordship, relying upon this document.
Yes. Learned counsel, you will withdraw.
Yes.
If you withdraw, we can say that. If we dismiss it, then how do we give you liberty?
Yes.
Learned counsel for the petitioner, having argued for some time, petitioners, having argued for some time, seeks permission to withdraw this specially petition, reserving liberty to the petitioners to approach the High Court by way of a review petition in the light of the recent judgment dated 17/10/2025, passed by a learned judge of the High Court in AS number 1048 of 2025 on the strength of the statement made by the, which respondent is
Union of India Minutes.
Deputy Collector. Strength of the concession made, don't say statement, concession made by the learned counsel for the respondent from Union of India. The permission granted, especially petitions accordingly dismissed as withdrawn with the liberty of first state.
Much obliged. So, you filed applications. Issue notice to the proposed legal representatives of respondent number 2.
There is a delay.
Returnable on all that. Notice will have to go. Returnable on 21st January. Otherwise, make it 28th January.
Item number 38.
Some months time.
The state has circulated a letter.
Yes.
The lordships
Adjournment is
only request if your lordships may call for the original records, it will assist in the adjudication of the matter.
Adjournment is sought by the learned counsel for the state of Assam to enable him to file a counter affidavit. Along with the counter affidavit, the original record shall also be produced. List on usual order. After that, you can file your rejoinder also.
Clarify the original record of the foreigners tribunal.
Original record of the foreigners tribunal.
I'm so grateful. And your lordship's interim order may be continued.
Original record pertaining to the foreigners tribunal. What is the case number? If you have that case
Your
number.
lordships, the case number is 60 of 2006. Before foreigners tribunal number
pertaining to case number 60 of 2006.
Yes, your
on the
lordship.
file of the foreigners tribunal.
Number 4.
Number 4. Kamru. Usual order, rejoinder also. And then earlier interim order dated 5/8/2024 shall stand extended till the next hearing. List on 18th February.
I'm so grateful.
Your Lordship, I'm seeking a short passover. Senior is held up in another court.
Item number 35.
May I please, Your Lordship? There is a marriage ceremony in the council for the petitioner family. I have circulated a letter, but due to delay, it could not be brought on the record. I am requesting for Friday.
Well, it's
Friday only, not more than Friday.
Well, in that event, would my lords consider keeping it on 28th?
Hmm. 28th you want. 28th is a Friday again.
Yes, my lord.
Subject to my lords, they are asking for 21st. I'm okay with then 21st. My lords will not adjourn it to January.
What is the hurry in the matter of this nature? Anyway, it's land acquisition compensation.
My lords, there is a interim order against me. So
That is true. It's
my
been there since January. So you can complete a year and then complete the matter.
I'm only making a request. If my lords can accommodate me anytime.
Based on 2nd December.
Obliged.
Take it up on a Tuesday. Will it take time, this matter?
My lords, will not take too long.
Very well, then 1st December.
I did that.
1st December, do we have a hearing matter? There is 5th December,
Yes.
5th also. 28th November, 28th also. One is there. Very well, 28th November.
I'm obliged.
We have filed our counter, my lord, but to best of my understanding, service is not complete, my lord.
Service is not complete, is it?
10 seconds on service. So the Lordship, I have the office report.
Service not complete.
Yes, so Maharaj, can I make a statement? Society is already represented. I think somebody called Kush. Somebody called Kush. So society can file wakalat. Others, Milas, I am not claiming any relief.
No, but you'll have to ask for the deletion. We can't.
Is it possible on my oral request or should I make
We insist on an application.
No difficulty, Milas. Lordship will file the deletion by tomorrow. Will also, would your Lordship consider keeping it for hearing on any day? I'll file a short.
Lord, I will pray for the non-miscellaneous day, my lord. The group company doctrine, Cox and King, my lord, and the subsequent judgment which has come from Justice Pardiwala's bench, my lord, that will have to be.
It's a later judgment. No?
Yes, my lord, 2025.
Is it Ajay Madhusudan?
Yes, Ajay Madhusudan has just come, my lord, where Cox and King has also been referred, my lord. And my lord,
issue of veritable parties.
Yes, yes. So my own understanding is that not sometime
Tuesday it may not reach very quickly.
Wednesday.
I
Or Monday, any Monday end of the board.
Lord, I am completely in my lord's set.
Whenever
my lords want.
Already a lot of hearing matters.
Whatever suits, any day.
Maybe a Wednesday would be.
Wednesday, any Wednesday.
Any
After
Wednesday,
2 weeks, Lordship,
to my lord's convenience.
We find that the service is not complete as yet. List for steps should be taken in that regard. Based on Third December.
Very grateful. Just give me liberty to file a short 1-page submissions on this. So that
short submissions not exceeding 2 pages.
2 pages. I'll file it. So that it's we just concretize this. Grateful to you.
But we'll also file.
Yes. Grateful to you.
But lords may just consider having 3 pages, my lord.
Very well. 3 pages.
3 pages.
Because my lord,
on submissions.
Yes.
3 pages. Font
14.
Double space.
1.5.
Double space.
And because margins also sometimes in moot court because we used to reduce the margins. Grateful to you.
Item number 37.
Lord's item 37 respondents have submitted letter to file counter.
We don't have a letter.
The letter was rejected, so I filed my counter affidavit on Saturday, my lord. Since
Before you
not
file
a
it.
record, my lord.
May not be here.
Yeah, it is not. The office report doesn't say so. I filed it on Saturday. Or if I have it on any other
I
day.
informed that the counter affidavit has already been filed, but the same is not on record. And the registry is directed to verify and put up the same by the next date of hearing. You need to file a rejoinder. And counsel for the petitioner seeks some time to file a rejoinder to the counter affidavit. It shall be done by the next date of hearing based on second, but you